Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss the suspension of sentence by the Division Bench of the High Court on Sister Abhaya murder case. So, please remember, suspension of sentence, it is envisaged in section 389 of the crpc, which says the Sessions Court, High Court, or the matter of Supreme Court may suspend the sentence till the disposal of the appeal. Right? The provision is 389 crpc. Only for making aware of the provision, I am making this video. Of course, it is a controversial case. The Sister Abhaya case, luckily, the CBI took up investigation. They filed the charge sheet. You may be knowing this took place on March 26th, 1992, or March 26th, 1992. It is written here. So this is relating to the death of Sister Abhaya, who was just 19 years old, and her dead body was found in the well of Pious Convent, and a lot of twists and turns have taken place. Ultimately, the court held that Father Kottor and Sister Sephy, Sephy, they were responsible for the killing of this girl, and they are given life sentence. In this, there is a twist also. So the court believed the version of three independent witnesses who are not at all connected to the Catholic missionary or any witness. And one of them was a criminal. Actually, he wanted to commit some property from the church, and he was waiting, he was lurking for the time. At that time, he saw this Kottor and Sister Nephi and somebody discussing something, and ultimately body throwing in the well, all these things he has narrated. So basing on the taking into consideration reliability of the evidence, the people were convicted. Of course, as usual, they were in jail, but now an appeal was filed. The appeal is pending till such time, on the request of the lawyers, the division bench has suspended the sentence. Right. Now, in this connection, the division bench noted that prosecution did not counter the defense theory effectively. Therefore, they are given the suspension of sentence. Right. So, in this connection, on behalf of the appellant, that is Father Kottor and Sister Sephy, it was argued that actually there was no evidence to show that Father Kottor and Sister Sephy met on the particular night. No recovery of the weapons. No evidence to show that the injuries were inflicted by the accused persons. This is their version. Of course, CBI, they stated that they believed the case, or they have constructed the case entirely on the so-called circumstantial evidence. Right. So therefore, the appellant advocate says the sentence is absolutely improper and incorrect, and it was vitiated by grave irregularities and illegalities also. Of course, every time we'll be writing like this. The Honorable Court did not consider the material facts. They have simply given the judgment like that. So, the conviction was given believing the three unreliable witnesses. It is totally unfounded story. Right? Then, the material objects not at all seized. Even though the seized material, they were not produced before the court. So, it is not a judgment of law, but yes, please remember, but a beautifully drafted screenplay on fiction. It is a fictitious story. So, assumptions, that's all. So, if such judgments are allowed, much travesty of justice will be done. Please remember, these are all the appellant's arguments, not the court's. These are all the appellant's arguments. Right? Anyway, normally suspension of sentence will be given. So, now, the division bench of Kerala High Court, so they have ordered for the release of these two persons with the sureties for 5 lakhs amount with 2 sureties, and on a condition that they have to appear before the concerned police station on every Saturday. Up to 6 months, every Saturday at 11 a.m. they have to report, and later after 6 months they can appear before the police station on every second Saturday, that is once in a month. So that is also time they have given. Of course, it's only to make sure that they do not go outside. That is the main problem. Because the appeal is still pending. The appeal has to be decided till such times. Normally, using the powers under section 389 CRPC, the High Court or Supreme Court or for that matter Sessions Court also can suspend the sentence. This is what happened. So, for making aware of all the developments, I have just touched the facts in a nutshell. So, please remember section 389 CRPC. Right? Thank you very much.